Good morning, Mr. Sultan.
Madam Chief Justice, and may it please the Court. Dr. Dirk Greineder was prosecuted for the murder of his wife, Mabel, who was killed in a public park in Wellesley on October 31st, 1999. Both the Commonwealth and the defendant were represented by experienced counsel, and the case was tried under the glare of intense media scrutiny before a highly respected senior member of the Superior Court bench. All the ingredients were in place for the criminal justice system to work exactly as it's supposed to work. But that did not occur. Rather, as a result of a series of serious errors committed by the judge, the prosecutor, defense counsel, and even the jury, Dr. Greineder did not receive a fair trial, and as a result, his resulting conviction must be deemed both unreliable and constitutionally invalid. Now, on appeal, the defendant raises a total of 9 issues. And usually, if there are 9 issues in a brief, what it would mean to me is that counsel is basically throwing everything but the kitchen sink at the wall and hoping that something will stick.
Yes, I was going to ask you, would you please address the most important issues?
Well, I will, Your Honor, but I want to say before I do that that is not the case here. In this case, there are 9 serious, meritorious issues, and I will address as many of them as I can get to in the limited time I have available, and I would hope that the Court will not hold it against my client if I can't get to each and every one of them. Let me start with an issue which affected the trial in a gigantic way, and that was the admission of inculpatory DNA test results through a witness who was completely unqualified as a matter of law to present those results. These were results which were created, which were produced by a Cellmark laboratory analyst named Wendy McGee. She produced the results, and they were presented at trial through Cellmark's laboratory director, Dr. Robin Cotton, who neither did the testing, served as technical analyst, signed the reports, or reviewed the raw data.
Could I ask you a factual question about that? And I'm sure it's in this, I mean, maybe I should know it, but I don't. So I understand your argument, and I know that Dr. Cotton gave her opinions, and my question is, how did she's testifying about charts, and how did the physical charts get before the jury? How did the actual, whatever they're called,
the electropherograms? Well, Your Honor,
electropherograms, how did they get before the jury?
Well, the electropherograms were not before the jury. What was before the jury is actually set forth at the very back of the first volume of the defendant's appendix. It's at pages 680 to 682. These are in black and white. The ones that were used at trial were in color. These were basically, they were blow-up charts which showed the results of Cellmark's testing. They were displayed during Dr. Cotton's testimony.
Evidence. How did those come into evidence?
They were not admitted. They were chalks. Okay, they were not. These charts were not admitted into evidence.
Weren't they given to the jury?
They were, Your Honor. Not only were they shown during the testimony of Dr. Cotton, they were handed out individually to the jurors. The jurors had their own copies of these charts during Dr. Cotton's testimony and also during their deliberations, and the notes are actually also in here. The jury asked for their own copies of these charts back. They had them in the jury room during deliberations. Judge Chernoff gave them to them.
So the underlying analysis that those capture was never itself admitted into evidence?
No, Your Honor. Simply the charts which replicate the results, which state at each locus what Wendy McGee found, which alleles she found to be present at each chart, at each locus on the 3 critical pieces of evidence. That was what was before the jury. Those are test results. They were the test results. They were the exact same test results that were in the reports. And, in fact, during her testimony, Dr. Cotton referred to the reports over and over and over again.
So these chalks pretty much corresponded to or tracked the testimony at trial?
Yes, Your Honor. She was testifying basically from the charts, with the charts in front of her.
She was giving opinions based on that factual basis.
Well, respectfully, Your Honor, I don't think she was giving opinions.
Well, but let's just assume for the minute. I'm not disagreeing with you, but assume for the minute that she was in part giving opinions. But the underlying data on which the opinions were given was also before the jury in the form of these these chalks?
Well, the underlying data, Your Honor, which were the electropherograms, were not, as I recall, were not introduced into evidence. The jury simply had these charts, which were essentially it was the lab report in a pictorial form. That's what these charts are.
I'm not saying it's appropriate. I was just trying to get the.
So they did not have the underlying data. They simply had the results, which were set forth both pictorially in these charts, which were chalks, which they had with them in the jury room during deliberations, and in Dr. Cotton's oral testimony. This was, in effect, exactly what this Court has said since Marquardt and McNichols and Evans and Nardi and Avila. This is what you can't do. You can't have the expert basically state the underlying results. Now, to some extent, she did give some opinions. At some point, she took these results and she stated her opinion as an expert as to, for example, their statistical significance. That's an opinion, okay? That, I suppose, in and of itself, arguably, she could do. But those statistical opinions aren't worth anything unless you have first accepted the reliability, the validity of the underlying results. And, in fact, Judge Chernoff told the jury as much in his final instructions. He said to the jury, quite properly, an expert's opinion is only worth as much as the validity, the reliability of the underlying information the expert is relying on. Here, that information was Wendy McGee's information. It wasn't Dr. Cotton's information. And no matter how many times the Commonwealth wants to insist she was just giving her own opinion and relying on this as source material, that's clearly not what this was. She was presenting both orally and in pictorial form the test results. These are Wendy McGee's test results.
Now, am I correct that this was done as part of the direct?
It was done as part of the direct. This was their case.
And it was done without objection?
No, Your Honor, it was objected to, and I'm glad Your Honor brought that up. When she first started to testify about the results, defense counsel objected on the grounds that she had not done the testing, which basically was, I submit, certainly put the court on notice that he was objecting on grounds of hearsay. He didn't say confrontation. This was pre-Crawford. But basically, the argument was there that she does not have a right to testify as to the results, and that objection was overruled. And Judge Chernoff did say at a certain point in the trial, you only have to object once per witness. So he didn't get up 27,000 times during her testimony, but he did make that objection in a timely fashion at the very beginning.
Okay, but did he also use this same information that he objected to as the basis of the cross-examination that he conducted of this witness for 2 days?
Well, sure, Your Honor. Once the evidence was in, once his objection had been overruled and she was allowed to basically report the results, of course he did the best he could on cross-examination to deal with it. But by then, the cat was out of the bag, and he had to deal with it as best he could. That's not a waiver.
But he needed to do, even if she had done it properly, he still, as part of his strategy, needed to cross-examine her on this data in order to undermine her opinion.
No, Your Honor. If she'd done it properly, she couldn't have done it at all, because the only way these results could have come before the jury under the Sixth Amendment and under this Court's rulings would have been through the person who produced the test results.
Well, if we don't agree with you about that, and we conclude that, no, she was entitled to give an opinion, but not testify on direct examination as to the underlying facts of the test results, was it then part of defense counsel's legitimate strategy to cross-examine her on these test results?
Well, Your Honor, if the Court finds that her stating what these results were and her showing them to the jury in the form of a chart if this Court finds that was an opinion, then I suppose there'd be no error under this Court's prior rulings. Whether or not Melendez-Diaz changes that is another question, which I've tried to raise in my reply brief. But I don't think that anybody in good faith can look at what she did, that is, basically taking the report, reading from the report, telling the jury at this locus there were 7 of Dr. Greineder's alleles present. There's a big chart which shows what the allele is, what the locus is. Those are Wendy McGee's results. That's not her opinion. She never saw the raw data. How could that be her opinion?
Well, if Wendy McGee had testified to the test results but had given no opinion, could the jury have come to the conclusion that this was a match?
Your Honor, if Wendy McGee had testified to the test results, then Dr. Cotton certainly could have taken the stand and given her opinion based on what the jury had heard, what had been properly cross-examined.
But you need an expert opinion in these cases, don't you?
Of course you do, Your Honor,
Okay.
but you also need, but you can't, as this Court has said over and over again, you can't put the underlying data in under the guise of opinion. And that's what happened here. And it was objected to. And, I mean, this is especially in the area of DNA, and especially in a case like this. And my second argument is that, you know, this never should have come before the jury in the first place because it should have been excluded on a pretrial Lanigan motion. Because here, what Cellmark had done was to stretch the technology so far beyond where it's been used, where it's been accepted. This was extremely minute. This is called low copy number DNA. These are tiny amounts of DNA. This is a mixture. And they reduced their threshold, at which they read these results down to 40 RFUs, far below the manufacturer's suggestion of 150, far below the FBI suggestion of 200, below what any other laboratory was doing. They went down, down, down. They didn't validate it at that level. And defense counsel should have moved to exclude this scientifically unreliable, invalid test results under Lanigan.
May I ask you a question on another subject, please?
Yes, Your Honor.
On page 4.
Before you go
go
to,
ahead.
can we just
Go
stay
ahead.
on the
I'm
DNA
sorry.
for 1 sec?
Go ahead.
Was the opinion that as a result of these tests, Dr. Greineder could not be excluded, or that there was a match?
Well, Your Honor, there was, in these kinds of cases, there was no perfect match.
No, I understand that.
But basically, the testimony was that, you know, there's a 1 in a million random match probability.
But he couldn't be excluded, but there was also statistical evidence as to what the actual matches meant. What wasn't.
Correct, and that was extremely inculpatory. In other words, it was basically that there's a 1 in a million chance that the DNA on the gloves, which the murderer presumably used, and the knife was somebody's other than Dirk Greineder's. That's pretty powerful inculpatory evidence, and it was really the centerpiece of the Commonwealth's case at trial.
But is the logical consequence of your argument with regard to what your answer was to Judge Spina that if Wendy McGee had died or had left for Tahiti, that this DNA testing would have to be done again, that nobody could give an opinion based on what she had done?
No, Your Honor. Anybody, any qualified expert could review the underlying data. That is the raw. And in this kind of technology, you have electronic data. That's what you start with, and then the analyst has to basically make certain important decisions, which is which data to filter out, which peaks to consider to be alleles, and which to treat as artifacts. Those are calls made by the technical analyst. If she's not available, somebody else can essentially replicate those same calls using the raw electronic data. But you have to start with the real data. You can't start with a filtered version of it and look at that after those calls have already been made. Those judgment calls, those discretionary calls were made by Wendy McGee. So somebody else would have to basically put themselves in the same position as Wendy McGee, not run the tests again, but look at the raw data again. Start with the underlying data and then come to opinions from that. That's perfectly acceptable. And as a practical matter, that can be done.
It doesn't matter that you're not. This shows my scientific ignorance, but it's not that if, for example, and I don't know in this case, if the sample had been exhausted, that's not a problem here because you had the electronic data?
Exactly, Your Honor. The electronic data is permanent, and anybody for eternity can look at that electronic data and reach legitimate expert opinions about it. But that's not what happened here. Dr. Cotton acknowledged on cross-examination that she had not reviewed the underlying electronic data, and the Commonwealth concedes it in their brief when they're talking about trying to defend defense counsel's job in dealing with the DNA. The Commonwealth concedes in its brief that she had not reviewed the underlying electronic data, and that the defense counsel, one of the reasons he didn't file a Lanigan motion was so we could exploit that at trial. So there's no question that she didn't review the raw underlying electronic data. And not having done so, she was not in a position to provide the jury with the test results. That's the thrust of that argument.
I have a question about what you say at page 4 of your brief. The trial court barred the public from attending individual voir dire. How did he do that?
Your Honor, based on the record, the individual voir dire took place in
courtroom 8, I know.
in private. It was private. The public was not permitted
Was
to
the
be there.
courtroom closed so that no one from the public could come in?
Your Honor, I have to say to the Court that there is nothing in the record which says that one way. What's in the record
And
is...
how do you make that statement?
Well,
You say
because-
the trial court barred, which is a pretty serious accusation,
the statement-
barred the public.
Well, the statement is simply Judge Chernoff's statement that we are here for a private voir dire. That's what a non-public voir dire. That's what he said. So certainly I interpret. I mean, this was a case with enormous public. There were media all over the place. There was family members all over the place. They weren't there.
I assume you've spoken to people who were there.
I was, Your Honor, but
Okay,
I can't.
so
That's not part of the record.
Were
Yes, people were barred, Your Honor.
people were told that they could not come in?
That's correct, Your
Or
Honor. But
did
that's
he-
not in the record.
But it's not in the record.
That's right.
But
And that's why I suggested in a footnote that if this Court is not comfortable with the state of the record as it is, that is simply relying on Judge Chernoff's comment, it will be completely appropriate on this issue to remand to the trial judge for further findings on that.
well, he's already made. Well, it's 33. He's already ruled on a motion for new trial. So
This
wouldn't-
issue was not raised on a motion for new trial. This issue is being raised in the first instance on direct appeal, which I submit is the appropriate way to raise this issue. Okay? That's why I raised so.
Well, we're lacking some sort of a record on it, because isn't it possible, the argument could be made that what he meant by a private voir dire was that the press and the cameras were not in the courtroom for this part of
Well,
the
Your Honor,
proceeding.
it is conceivable that's what he meant. I would not have raised this issue if I had not done my own investigation and concluded that that's not the case, because otherwise then if this court remanded, it would be a waste of everybody's time. So I submit that that the public was not permitted to attend the individual voir dire, there was no waiver of a right to public trial by my client, and under Owens, that is structural error.
What about Horton? What's the difference between this and Horton?
Well, several differences. Horton was raised on ineffective assistance of counsel. This is being raised on direct appeal. So that's issue number one. Here I'm simply saying as a matter of direct appeal, my claim is that my client's Sixth Amendment right to a public trial was violated. So that's number one. Number two, Horton predated Owens. And frankly, I think in the way this is a federal issue, and I think that in general this court makes its own judgments, but this court carefully looks at federal court interpretation of federal constitutional provisions, and the First Circuit recently in Owens said quite clearly this is structural error. So I would submit that Horton, to the extent that
you can waive structural error, and I understand this is 33E, but it still seems to me it gets you what structural error means is that you don't have to show prejudice.
That's right, Your Honor.
But it seems to me you may still need to show in this case that there is a substantial likelihood of miscarriage of justice.
Well, Your Honor, I think that is essentially the same as prejudice, and I submit that if that becomes a standard, then nobody is ever going to be able to. This becomes it becomes a hollow right, because you can never prove
it doesn't become a hollow right because often, in very many of these cases that raise this Sixth Amendment public right to trial, the issue has come up because the defendant or somebody that is connected to the defendant has sought, it's part of the record, has sought admission, has been barred. We don't have any of that here. We have the defendant wanting individual voir dire. We have, I think there's no question that individual voir dire itself, I understand that this isn't the same thing, but individual voir dire itself can be taken, has to be taken outside of the hearing of the public.
of the other jurors, Your Honor, not of the public.
Well, no, I would suggest to you that I don't think that the Sixth Amendment requires that when you are having a conversation with a potential juror about his or her, let's just take a different case. Let's say it's a rape case, and so there's questions about sexual assaults on that juror. All those people that are sitting in the back of our courtroom here don't have a right to hear that.
I agree, Your Honor. For good reason, the court certainly, and under the case law, the court can either, based on a series of questions or even based on the overall situation at trial, can make findings that can justify doing things in a non-public way. But that didn't happen here. There are no findings, and it was done across the board. It was done for the entirety of individual voir dire for 2 days. And that's a serious violation, and if it's to be taken seriously, and if this Court is to pay attention to Owens, which it can do or not do as it sees fit, under Owens, I think clearly I'm entitled to relief.
Could I ask you one more question? I'm sorry.
No, you can keep going.
Were there general voir dire questions to the jury somewhere and then a move to courtroom 8 for this, or?
There weren't, Your Honor. The jurors filled out questionnaires, and that was sort of in lieu of general questions. And the entirety of voir dire took place in this separate courtroom, I submit, in a non-public place where people were not allowed to be.
Where did the judge, you know, in the usual impanelment process, the judge has various panels in front of him or her and explains what the case is about and explains the principles of proof beyond a reasonable doubt, et cetera, et cetera. Did that ever occur for a lot of panels altogether?
My recollection, Your Honor, is that that entire process took place individually. There was
Individually? The judge explained to each person, the hundreds of people who must have been called?
Was it all in the written questionnaire?
I think it was all in the written questionnaire, Your Honor, but let me, I just want to make sure I'm being accurate, so let me just check if I can.
Mr. Sultan, you
Yes,
can
Your Honor.
certainly send us a letter,
Okay, I
because
will do
rather
that.
than
Thank
you
you.
flipping
But
through that.
before you sit down, could I ask you one question? What should happen in these circumstances? Should a judge make findings and then exclude the public, or should a judge conduct an individual voir dire at the sidebar in view of the public but out of hearing of the public?
Your Honor, what federal case law says is that the court has to make findings. The court has to make findings on the record explaining, number one, why a non-public proceeding is necessary, and B, that what is being done is the least restrictive to the public.
Is there anything that would prevent a judge from conducting an individual voir dire over at the sidebar with a full courtroom, in the presence of a full courtroom, but out of hearing of the public?
Not that I know of, Your Honor. That's I mean, sidebars happen out of the hearing of the public all the time. That's part of what we do in court. But that does not mean being barred from the courtroom entirely. That's what happened here.
I understand the distinction, but I have a hard time analyzing what the difference is if you call every juror up, which is a practice I know that's followed a lot of time. Every juror who raises his or her hand is called up to sidebar and is questioned quite quietly by the judge and the lawyer so that nobody else can hear. I mean, that's the whole purpose, because otherwise people won't tell you the truth if you ask in front of a lot of people. So what is the difference? That's where I'm
Well, Your Honor,
drawing a blank.
as a practical matter, I think Your Honor, who obviously sat as a trial judge for many years, I think is absolutely right. There may not be any practical difference as to what the people can hear or not hear.
Or the public or anybody else.
Right,
Nobody hears what goes
But
on.
systemically, we believe in public trials, and public trials means the courtroom doors are open, people can sit in the audience, they can hear what they can hear.
But if we get to that point, which is why I asked you the question in the beginning, because that's how I see it, then we would need some evidence that the courtroom doors were actually closed to other members of the public. And I don't see that in this record, because I don't see the difference between what you and I just talked about and what happened here.
Well, Your Honor,
and that happens in
well,
virtually every trial.
Well, I agree, Your Honor. There is nothing in the record that says the door was locked. If the court, if
And
that
we
is
have
the
no way of
issue, I would
knowing.
ask the court. I would welcome a remand I mean, the Commonwealth does not even allege that the doors were open.
Well, the Commonwealth does say no suggestion that the courtroom was closed to the public.
What they say is the record is what it is. If they were there, I submit, if they knew that the doors were open, they would have
They
said
also
so.
say that there were a couple of real sidebars in this, which would suggest that there are other people in the courtroom than the juror who was being
I don't know
examined.
what to make of that, Your Honor. There was a sidebar during this private voir dire proceeding. I recognize the sparseness of the record on this, but to me, I'm stuck with the record as it is. I think this is a serious issue, and I would welcome the court remanding for fact findings on this particular issue.
Mr. Sultan, is there any question that any judge would have, if they had to make findings, would have found that it was necessary to exclude the public from this individual voir dire?
Sure, Your Honor. I think we have all the time. We have trials where individual voir dire takes place at sidebar, where the public is present in the courtroom. I think that happens every day in the courtroom.
So you think in this particular case, a judge could have conducted an individual voir dire by placing the juror in the witness stand and testifying openly in front of the entire courtroom. Could have done that in this case.
That's one way it could have happened, or it could have been done in a
No,
variety of ways.
Yes. Was there anything about the jury questionnaire that solicited very private information from the jurors?
I think the jury questionnaire did raise questions about whether the jury would be able to hear evidence involving sexual matters, that's the one that occurs to me.
Did it ask the jurors, did the questionnaire ask the jurors if they had been victims of sexual abuse?
I don't recall that, Your Honor, one way or the other. I'm sorry.
Mr. Sultan, I have a couple of questions. The first, in connection with the closure issue, did any representatives of the media object to the proceeding?
There's nothing on the record, Your Honor, that indicates that.
And second, if I could go back to the argument that you made about the failure of trial counsel to ask for a Lanigan hearing. As you know, the trial judge concluded that there was an explanation of why he didn't do that, why trial counsel didn't do that, specifically that he was concerned that in conducting such a hearing, it would expose the weaknesses in Dr. Cotton's case. What am I supposed to make of that?
Well, I think that obviously this court has to evaluate whether or not that was a reasonable strategic reason, and unless it was manifestly unreasonable, it's not ineffective. I submit it was manifestly unreasonable. He never cross-examined Dr. Cotton about the lack of validation of RFU calls under 100. He never cross-examined her about the lack of substrate controls. He didn't raise the issues which Dr. Eisenberg in his affidavits says invalidated the scientific testing. None of those were raised on cross-examination. So
if he's saying it was a tactical move because I was going to do it at trial, and
he
then
didn't
he
do it
didn't
at trial. Yes, Your Honor.
One other thing which has to do, is it Labila?
Your Honor.
I'll ask the Commonwealth about this because this was a very focal point of the closing argument, correct?
The DNA, Your Honor.
No, the heel print.
The heel print, Your Honor. Yes, Deborah Ribera was the state police sergeant. It was, Your Honor, and Judge Chernoff so found that it was a focal point of the closing. And this is a recantation by their expert, and the jury basically received false evidence, very important false evidence, which directly fit into the Commonwealth's theory that Dr. Greineder had dragged his wife's body. That's why his heel print supposedly was in the dirt there. And 7 years after trial, or 6 years after trial, the expert files an affidavit saying, oops, that was wrong.
You're suggesting on the issue of the closure of the courtroom that the press, and this was a highly publicized trial, I think that's part of your brief, you're suggesting that the press was barred from this voir dire, yet no members of the press came up and to the single justice and complained. It just seems highly improbable scenario today.
Well, Your Honor, I think what happened, I wasn't at President trial. The record is what it is, and it's sparse on this point. There were some indications in the record that Judge Chernoff met with the press, and perhaps he at that meeting set forth certain ground rules, and they worked it out. But all I know is that the record states this was a non-public voir dire. And there's nothing in the record to the contrary. Non-public means to me that members of the public are not permitted to attend.
So it's based on that one word.
Well, and I think it's further up on the same page he uses the word private. So it is in terms of what's in the record, that's all that's in the record. But and obviously my own investigation is not properly before the court. And if the court wants further fact finding, I think it's completely appropriate, as it's done in other cases, to remand to the trial court as to whether or not the public and the press were in fact actually barred from the voir dire.
Before you sit down, Mr. Sultan, I'm sorry. I just want to go back to the heel print evidence.
Yes, Your
I
Honor.
want you to help me understand. Judge Chernoff goes through, makes lots of findings of fact, sets out the law, and then essentially says the heel print evidence might have overshadowed. That's pretty strong. And then he says, however, without the heel print evidence, the prosecutor would probably have offered alternative theories of the dragging of the victim. That's a probability. And then, although these likely would have been less persuasive, what am I supposed to do with the trial judge essentially hypothecating about what might or might not have happened? I mean, how am I looking at that?
Well, Your Honor, I think that the speculation as to what they might have done had they had the true evidence about this print been available to everybody is really not worth much. I mean, what's important is what the jury heard. What the jury heard is the defendant's heel mark is right next to a drag mark where the victim's body is found. That is a powerful inculpatory evidence, and it was absolutely emphasized by the prosecutor in closing. That's what they heard. This court should find that probably had an impact on the jury, a substantial impact on the jury during its week of deliberations in reaching a verdict in this case. What could have happened, woulda, coulda, shoulda, if they had done their job properly instead of presenting false testimony is really beside the point. It influenced the jury's verdict, and that's why the defendant's entitled to a new trial.
Thank you, Mr.
Thank you, Your
Sultan.
Honor.
Good morning, Ms. Kukowka.
Good morning, Your Honors. Varsha Kukowka for the Commonwealth.
Okay, could you explain, please, your statement that there's no suggestion the courtroom was closed to the public? On what do you base that?
A couple of things. The sidebar that took place, and the fact that no one has come forward and said that they were barred from the courtroom. Third would be, as Your Honor said, and I wrote in my brief, that no member of the press objected to this, although they were quite vocal on other points.
Well, as far as the sidebar is concerned, I assume that, maybe correct me if I'm wrong, that other members of the voir dire were in the courtroom. Other members of the voir dire were in the courtroom while
What happened was there were every available courtroom, and the appellate court was sitting, and a murder trial was going on in the main courtroom. Every other courtroom virtually was filled with jurors from this potential pool for this trial. And so the judge and the attorneys went from courtroom to courtroom just introducing themselves. And then the potential jurors filled out lengthy questionnaires.
Okay, but who was in courtroom 8?
When they came in,
During the questioning, was courtroom 8 filled with potential jurors in the back of the courtroom, or no?
From my reading of it, no.
So we don't know.
That individual jurors went out, and then another one came in.
And who else was in the courtroom?
Well, it doesn't show that any person other than the parties and the judge and the individual.
Okay, well, this is what I'm saying, then. If nobody else was in the courtroom, it would not have been necessary for the judge to have the sidebar. That's what I can't reason it out from
That's
from
right.
what is said.
Except that you could have had a sidebar to discuss between or among the lawyers and the judge to discuss this particular juror's answer and whether the juror should be excused for cause or not for cause.
Well,
that would be at a sidebar.
in the sidebar that is on the record, that juror had already left the courtroom.
So then there'd be no need for a sidebar if there's nobody else in the
Unless
courtroom.
there were other people.
Ms.
I mean, I
Kukowka,
can't say who or...
Would you agree with me that if there is a closure of the courtroom, that is a very serious matter?
Well,
yes,
it
yes.
depends if a judge actually makes a decision
Of
to
course,
close
of course.
the courtroom.
But here, what we're hearing is questions. It's not. Why wouldn't we just want to find out what happened? I mean, this is a very serious charge. It's a very serious matter. Why wouldn't we want to find out what happened?
Well, for one thing, the defendant wanted it this way. He wanted the jurors to speak away from everyone. He said they would not speak about this in public.
But that can be done at sidebar while the rest of the jurors sit in the back.
It's done all the
courtroom.
time. It's done all the time. The last time I was called for jury duty,
So
it was done.
Then the public would not be hearing.
No, but the public is
Anything.
present. The public is present. It's very important that the public be present. That's our case law. It's the federal case law. It's constitutional case law. It's of long standing. You can have the public present, and there are lots of sidebars where the public cannot hear before a trial, during a trial, after the trial, but they're present.
I'd say on this record, 8 years later, to say that this case on direct appeal should be remanded when the defendant brought numerous claims in his motion for new trial that went on for several years with hundreds of pages of affidavits that he could not have presented this, and to ask for a remand is absolutely against what should occur here. What should occur is that this court should look at what he's presented on his direct appeal on this issue and say there is nothing in the record that shows that this judge closed the courtroom and that the defendant wasn't perfectly satisfied with the procedure that did take place.
Am I correct here that the juror would take the witness stand and testify during the voir dire?
Yes.
So this was the what I call the old style of voir dire, in which the person would actually take the witness stand and would be questioned by the judge on the witness stand.
I wasn't in the courtroom, but it looks like that's what happened.
So which means that if it were not closed, anybody could hear what was being said. It would
They
be
could.
essentially a public voir dire in terms of, it would not be a sidebar, it would be a person speaking to an entire courtroom about what their
Yes,
answers were to
exactly.
questions.
Are you suggesting that perhaps what happened was courtroom 8 was used for these individual voir dires, but it was not closed? Anyone could have walked in.
That is exactly what the record would suggest, Your Honor, and
But the record could also suggest the opposite. We don't have a record. That's my problem. Would
This-
you agree with me that if there was individual voir dire and the judge had said, I've decided that we're going to have private voir dires, and that everybody sort of understood that, you can have private voir dires, but he actually didn't let people into the courtroom, is that a problem from your point of view?
that's speculative.
No. If that happened, is that a problem?
It depends on the case, Your Honor. If the defense asks for, to have nobody else in the courtroom, I mean, it depends on what
Are
happened.
you suggesting that the defendant waived his constitutional
I
right
absolutely
by asking,
am. Yes.
with counsel asking,
Asking it to be
does the
done
record
this way.
support, does the record clearly support that the defendant asked for this procedure?
I would say so, that he said that the jurors aren't going to want to speak about this in public.
Yeah, but do you need a colloquy with the defendant individually and a waiver of a constitutional right?
Well, the defendant certainly was in the courtroom.
But there was no colloquy with the defendant.
See, the difficulty is there may be lots of different, there was no colloquy, correct, with the defendant?
There's nothing on the record about a colloquy about having the procedure done this
See,
way.
there's a difference between, as I keep repeating, many times, and in many different trials, jurors are called up and they are questioned, not publicly, i.e., the public cannot hear what they are saying, but it is a public proceeding.
Yes, that's true. And
So if he's saying, the jurors won't want to say things, in other words, let's assume for a moment that this defendant does not want to have on the jury people who have been the victims of violent assaults. And let's assume that it is reasonable to conclude that people who have been victims of violent assaults may not want to express that publicly. And so you have a public proceeding, and you call up potential jurors, and you have what we call a sidebar, private, but it's taking place in open courtroom. I just can't tell what's happening here.
with the amount of attention that this case had, it was televised gavel to gavel on court TV, and the members of the press were all over it. To suggest
Was
that
it televised, gavel to gavel, was it televised during the voir dire?
of course not.
So why does your statement help me?
Because members of the press had such an interest in this that had they been barred, and they certainly know their rights under the First Amendment, there would have been one of them stepping forward, which has happened in other cases where they have come to a single justice.
If they know they're not going to be able to film it, because you just said to me, of course not, why would channel whatever it is, 2, 4, 6, 8, 10, or 12, go and ask to have cameras in the courtroom?
Not
Because
to
it is-
ask to have cameras, but to be present.
Well, I don't know who was present. You've told me about gavel-to-gavel television coverage. What I'm saying is that there are inferences upon inferences without a record.
We have differing opinions on what the record shows and what should happen at this point.
But I assume your position is that even if the courtroom were closed, it's waived?
Yes, that it was done according to the defendant's request, desire. Everything was talked about, and that it was at his request that it was done this way. And even if it wasn't, it was certainly waived. To bring it on direct appeal is certainly not the best way to bring one of these claims. When there's no one saying they were barred from the courtroom.
Yeah, but that's not my question. My question is, if we assume for our purposes, I mean, to avoid a remand, I think we probably have to assume that it happened, and then find that there was no error.
That's my point, Ms. Kukowska.
Are you saying that if we assume that you argue that there was no error in doing that?
Yes, if you assume that, which I don't think the court should, but if you did assume that it was waived, which I did address in my brief as well. As far as the Crawford issue, what happened here, it worked exactly the way it's supposed to work. Dr. Cotton reviewed an enormous amount of data and came to conclusions and testified about her conclusions.
But the data was before the jury, and it wasn't, as far as I can tell, it doesn't seem to me that it was either A, admitted, or B, was independently admissible.
Well, certainly it's independently admissible, but results of DNA testing, according to...
Well, let me, I shouldn't have said that. I misspoke. It wasn't admitted. It wasn't admitted, but it was before the jury.
It was before the jury. If you analogize this to, well, first of all, we have our body of case law with Sparks, McNichols, and Hill that talk about the actual analyst doesn't have to testify, that the laboratory director can testify.
Well, you're saying Nardi controls this.
Yes, Nardi and Avila.
But
it's a little
that's not in your
different.
favor. Nardi and Avila don't help you here.
Well, it's a little different because a medical examiner compared to data, what I would compare it to is that she gave her opinion based on the underlying facts and data. And below that is what came through in cross-examination. If you were to analogize it to a medical examiner, which is difficult, but everything that came out on cross-examination, which is why I say it works the way it's supposed to, is that those different calls that were made as far as whether you could call something an allele or not went through cross-examination, not direct.
But isn't that after the judge has overruled the defendant, at least as I understand from Mr. Sultan this morning, after the defendant has, the defendant has objected to this coming in as evidence, overruled, comes in as objected to the, not coming in as evidence, but being used in this way, overruled. What is the defense counsel supposed to do at that point?
Well, I would say the objection, which in the Avila case talked about the way the defense objected, and that really analyzed, what was the objection. Here it was simply she didn't do the testing. In Avila, the defendant had objected to the substitute medical examiner talking about the autopsy results, but didn't on direct, but didn't specify what was not admissible. So here I'd say it's even less of a preserved objection to simply say...
Well, except that if the objection was that she didn't do the testing, and she's testifying about the testing, that's the hearsay objection, isn't it? Isn't that the same thing that happened in Nardi?
Yes, I mean, he did object but it was kind of a pro forma by saying, well, I think Sparks applies to this.
But wasn't it the case in direct that the photographs that Mr. Sultan showed us from the record were before the jury on they were called chalks, but they were all up there, and she was talking about them, right?
I think the electropherograms that she looked at, yes, but I would say that Judge Chernoff on the last day of deliberations responded to a jury question asking for electropherograms, that they could not have them.
Well, but forget that.
But
It's at
yes,
trial.
Yes, it was displayed, and
He was
then
talking about what they showed, wasn't she not?
yes,
And the judge in his memorandum on the motion for a new trial says the DNA evidence in this case was, and then proceeds to describe all this stuff, not her opinions. Says this was the evidence. That's him, not me, not you, not.
you'd have to say that it's not permissible to give an opinion on DNA then.
No.
That's not so. What I think all we're asking you about is to give an opinion, it's got to be based on something that would be admissible. That's number one. But it's got to be based on evidence. In this case, it seems as though the factual evidence that forms the basis of the opinion was indeed before the jury, but not ever properly admitted into evidence. So it was before the jury as though it were admitted, but it wasn't. And she was rendering her opinion on it and sort of going through in the form of opinion, putting forth the facts that formed the basis of it.
The raw data is something she didn't look at. Then the process is it goes through a stage where there's electropherograms, and then the software produces further results. I think what she was basing her opinion on was everything that she saw except the raw data, and she came to her conclusions based on that.
I'm sorry. Could you address the changed testimony on the recanted testimony on the heel print?
I would be happy to do that, Your Honor. One thing I want to say is, in the closing argument, the word heel is used many times, not many times, but a number of times. But it's important to realize that not every time the word heel is used does it refer to that heel mark of the defendant in the blood. Most of the time, it's referring to the victim's heel, which remained at the end of that drag mark and was not moved. And the importance of that was that that she had been dragged to that spot and left there, not had been tried to be picked up 3 times, which would have jostled the body, but exactly where. So there was no disturbance. So I really want to emphasize that in the closing argument, many times where the word heel is that it refers to May Greineder's heel. In fact, there's only 2 times, and the prosecutor was...
I understand, but the trial judge is talking about the heel print. I mean, he's talking about the heel print that was linked to the defendant.
Yes, but the prosecutor said the wearer of those shoes at one point, which is more to the point, that he was marshaling the evidence that he had, which was not false testimony, but erroneous, that Sergeant Ribeiro had given, that she had said it was a heel print. So he was marshaling that to say it was the heel print moving, dragging backwards. But there was other evidence, in fact, even from the defendant's blood spatter expert, that the spatter on his shoes was consistent with picking someone up and moving backwards. And the 2 Commonwealth experts testified that the blood stains on the jacket were consistent with someone putting their hands underneath a body and holding it like this and moving backwards. So certainly there was other evidence that led to the inference that the defendant had picked up May Greineder's body and moved it.
As a matter of curiosity, what occasioned this trooper to go back and re-examine the evidence as to whether it was a heel or a toe?
Well, in the motion for a new trial, the defendant had filed an affidavit from Mr. Bodziak that said it is not the heel of the defendant, it is the toe of the defendant. Now, I would say if she had come back and said it's not the defendant's shoe, there'd be a viable claim. But to say it was the toe when there was very little identifiable footprint anyway, all of which was the defendant's, there's just no real import. I mean, yes, the Commonwealth did use this.
So you're saying whether it was his toe or his heel is really immaterial. The important thing is that the evidence suggests that he reached underneath her and lifted her up.
Yes, and that it was his footprint in the blood, and that the blood spatter was all over his clothing. Not satellite spatter from moving her, but blood spatter from being present at the violent assault when blood was in flight. I will say that the trial counsel, to say that he was ineffective in his handling of DNA would just be a travesty based on this record. If you see his testimony at the evidentiary hearing of what he put through, the extensive, exhaustive consultation with experts, the transcripts that he got from the Whitty case in New Hampshire and the Hunt case in California.
No, nobody's questioning whether or not he was, whether he underwent trial preparation. I thought the claim here was that I forget, I'm worse than Justice Botsford in terms of terminology, but, sort of taking smaller and smaller and smaller and smaller amounts of materials and subjecting it to DNA testing is not consistent with...
But the experts that he was in contact with apprised him of this information, and in connection with them and in connection with the defendant himself, who was very knowledgeable and wrote 25-page memorandum to his counsel on this DNA, the decision was made not to challenge it in a Lanigan hearing.
No, I understand that, and then Mr. Sultan's response to that, and we'll have to look at it, is his explanation, which was accepted by the trial judge post-trial, was I wanted to hold back so that I didn't want to reveal essentially what my tactic in cross-examination...
Well, that was one reason. Another reason was that from his view and looking at all the DNA evidence across the country was coming in, and that these issues, as DNA was evolving, went to the weight, not the admissibility, in all these long evidentiary hearings like the Hunt case, which went on for weeks, I think, and involved many different cases.
DNA was clearly coming in, but the question is, how do you challenge it? And
Right,
one way to challenge is that the amounts are so small that you really can't conclude anything reliable from that.
Well, for that, I would suggest that this court look at Dr. Cotton's two affidavits, which do speak to cell marks, validity studies, and that this was good science, in contradiction to the affidavit that the defendant had presented, and it certainly corroborates Mr. Murphy's decision on not going forward with the Lanigan hearing and the judge's ruling that he would probably not have allowed exclusion of this evidence. If there are no questions, Your Honors, I will rest on my brief and ask this court to affirm the first-degree murder conviction of May Greineder.
Thank you, Ms. Kukotka.